The accused person herein has been charged with the offense of conspiracy to commit a felony contrary to section 393 of the Penal Code. And the particulars of the offense are that on diverse dates between the 7th day of August 2023 and the 26th day of December 2023 in the Republic of Kenya, jointly with others not before court, you conspired to commit a felony, namely stealing USD 1 million, equivalent to 156,000 Kenya shillings, from Ying Chen Shenzhen International Trading Company Limited by falsely pretending you are in a position to sell the company 84 metric tons of tantalum, niobium, or tantalite, ferried in container numbers Segu 2490020, Segu 3374174, and Temu 028134, a fact you knew to be false. For count 2, you've also been charged with the offense of obtaining money by false pretenses, contrary to section 313 of the Penal Code. And the particulars of the offense are that on the 26th day of December 2023, in the Republic of Kenya, jointly with others not before court, with intent to defraud, obtained USD 1 million, equivalent to Kenya shillings, 156 million Kenya shillings, from Ying Chen Shenzhen International Trading Company Limited by falsely pretending you are in a position to sell to the company 84 metric tons of tantalum, niobium, or tantalite, ferried in container numbers Segu 2490020, Segu 3374174, and Temu 0281304, a fact you knew to be false. Now, the complainant herein is one Michelle Hu. Who was the complainant herein? She was the complainant and testified that she lives in southern China and works in the international trade and import. That she does business in various countries to her Chinese clients, and that this was the first time she did business in Kenya and sale purchase agreement, which is dated the 7th day of August 2023. That on the 31st day of July 2023, she avowed that she was introduced to a Taiwanese national called Patrick, who sent her several photos of the products, and the same was in Mombasa. He sent her 58 tons of goods and were going for 340 USD per ton. This was the first time to engage and was able to purchase 5,000 tons. She testified that the price was quite high and she was not able to buy a bigger consignment. She further said that she would try with 5 tons for a trial. The agreement was to send 10 tons, and the first batch was a 5-ton package. There was a signature of the agreement. There was a sales and purchase agreement which was adduced before court. There was an invoice dated the 11th day of August 2023, and there was a Eurospace amount of 164,800 USD. Patrick acted, I jumped the gun. Patrick acted as a contact person in doing the transaction on her behalf. She testified that she entrusted Patrick to send the 5 tons before the 10th. She testified that she did not entrust one Davis Otieno to do a power of attorney, but the seller in this matter is one Sanjola Company Limited. The buyer is the International Trade Limited. The titanium origin is the Republic of DRC, and it was at 280,000 USD per ton. She testified after she paid for the goods, but the same was never delivered. The customs denied her to have her goods sent in bits. She testified that she became suspicious of the business and asked for a refund. She testified that she used the China bank to send the 1 million USD. That was on the 8th of October 2023. She sent the 270 USD, the second amount, which was adduced before court. The first one was on the 25th day of September 2023, and the second one was on the 9th day of November 2023, which was written because the seller could not deliver in time. Now, on the 26th of December 2023, she testified that she paid the 1 million USD per the bill of lading. She testified that she later found out that it was fake and it was done by one Patrick, the Taiwanese national. After inspection, it was realized that the cargo on arrival in China was fake. The goods were fake. Sanjola sent an email to Moses Gabriel, and she paid the 1 million USD, and the customs verified that they were cement, thus fake goods, which were produced in quotas Exhibit 1, 3, 4, 7. She tests whether she recorded a statement in Kenya at the DCI. The container was shipped to China, which was bill of lading was Exhibit 10. Weight was 76299. The bill of lading was not equivalent to what was sent via email. The statement was produced as Exhibit 9. The bill of lading, Exhibit 10. She further tests whether she saw the charge sheet, which is actually Exhibit 11. Sidia Bank sent it to one Mose. The email came in from Sidian Bank, the dated 27th of September 2023, which was adduced before this court as Exhibit 12. Exhibit 13 is dated the 28th day of August 2023. She tests whether she could not pay on time, and she managed to pay the 164,000 USD. She said that they could not send the same unit until she clears. The document was produced as Exhibit 14 as an international settlement debit advice. Now, eventually, PW1 testified she was never refunded the money, and there was an Exhibit 14. There was a transaction notification, which was also sent via the email. The second payment being the 270 USD after the payment receipt kept on going with delays tactics, which was eventually produced as Exhibit before this court on the 11th day of December 2023. Now again, other exhibits produced the bill of lading, as Ali had said, and in cross-examination, she said that the pro forma invoice had no relationship with Sanjola. She testified that she did not entrust one David, I think that was the person who was given the power of attorney, and that on the 2nd day of October 2023, there was an agreement which involved Davis and one Sanjola. PW1 testified that she knew the Gabriel Kalonda. Now, the goods were to be stored in a warehouse in AGL, but she averred that she did not do the analysis, but Sanjola did. CCCI was the intermediary, and they did not see the goods. It is a Chinese company. Analysis report was in page 14, which was about 58 tons. She also said that she did not sign the documents, yet she confirms that she was importing 84 tons, but she signed two other documents. One was dated the 11th day of November 2023, and this she confirmed that she signed. The certificate of weight is in page 14, and she said that she got the contract of titanium and analysis was done. Sanjola was to export the same, and she received a video of the consignment. That was on page 38 of the contract. Now, one Mose and Company Advocates was the lawyer who was used in these transactions. And then the photos were taken on the 31st of July 2023. But on opening the seal and the container number, they were different. And what was found was sand in 3 containers. The shipping company was KMCC. She testified that she paid money and was never delivered. Those money which was sent to the council, Mose and Mose, which was $1 million USD, which was deposited in his account, and which is an exhibit before this court. Now, in total, I will jump. It's about 90 pages. I'll not read everything. But in total, the prosecution produced about 40 witnesses, and thereafter, the court ruled that accused person had a case to answer and was put on his defense to comply with Section 211 of the Criminal Procedure Code. Now, the court appreciates all the evidence adduced by the 40 witnesses, both by the prosecution and the defense. However, now, issues for this court to determine are as follows. Number 1, was there conspiracy to commit a felony by the accused herein? Did the accused obtain money by false pretenses? Did the accused deliver the mineral that he was paid for? Was there any legal binding in all these transactions? Was the titanium authentic? Now, as per Section 393 of the Penal Code, and provides as follows, that any person who conspires with another to commit any felony or to do any act in any part of the world, which if done in Kenya would be a felony, and which is an offense under the law in force in place, where it is proposed to be done, is guilty of a felony and is liable if no other punishment is provided to an imprisonment for 7 years, or if the greatest punishment to which person convicted of the felony in question is liable is less than imprisonment of 7 years, then to that lesser punishment. Okay. Now, to secure conviction for conspiracy, the prosecution does not need to prove that the suspect successfully completed the crime or that all the conspirators even knew each other. According to Kenya, this is a case law, Asuga versus Republic, and the prosecution must establish two things beyond reasonable doubt. That is, one, the meeting of minds. Number two, the intent. Now, in Kenyan courts, frequently, Section 393 involves fraud, corruption, premeditated crimes, notably legal principles from the Kenya law reports. The evidence is required. Merely pursuing an unlawful object at the same time is not enough. There must be an explicit proof of a shared plan or common design. The sentencing, it can be found in Elijah and two others versus Republic. Now, in Gashaga versus Republic, 1993 Kenya law report, the Court of Appeal held that, and I quote, with respect to the offenses of conspiracy, the crucial issue is whether the appellant and his fellow conspirators acted in concert with the intention that the board be induced to part with this money. In Ann Wangeshi Mugo and 6 others versus Republic, the court observed as follows: to prove a conspiracy, the prosecution had to establish that the respondents, together with others, agreed by common mind to defraud the complainant. The inference must be both made from the actions of the accused and the evidence tendered in court. See again Republic versus Ann Atieno Abdul and others, and further in Halsbury Laws of Kenya. Now I get to where we need to get. Now, for the first charge, the accused person was a sole witness, a sole accused person, and the threshold for conspiracy cannot stand as averred that the others are yet to be charged, or rather arrested and thereafter charged. As such, count 1 will fail. On the second count is that of obtaining by false pretenses. In Kenya, obtaining money by false pretenses is a criminal offense under Section 313 of the Penal Code. Any person who knowingly uses a false representation and an intent to defraud to induce another person to part with their money or property is guilty and is liable to an imprisonment of up to 3 years. Now, the key legal elements are the pretense. For the prosecution to secure a conviction, they must prove the following elements beyond a reasonable doubt. And one is the pretense: a specific representation of fact was made. Number 2, falsity, that the representation was false in fact, and the accused person either knew it was false or did not believe it to be true. Number 3, inducement. The false pretense actively induced the victim, the owner, to part with their money or property. 4, intent to defraud. There was deliberate, calculated intention to deceive and deprive the victim of their property permanently. 5, the item obtained is capable of being stolen. Now, in analysis, here is a story of an alert by the DCI of a money laundering scenario. Money is passing from one hand to another, but they can't lay a hand on where is the money coming from. PW12 and PW13 are the investigating officers, and as a court, I must give a standing ovation and their team for piercing up this together. In the midst of tracing money, which they did not know whose money it was, a high alert was posted. No complainant, no suspect. All leads now go to Mombasa at the port, and their containers, which allegedly have titanium, these are then held as exhibits from Mombasa Container Terminal. That is Temu 043-1657, Segu 2397370, and the last one was 8755716. The above one sealed, and they had 2 custom seals. They found them with some substance, and he put in an inventory of the seals and the substance and signed the same. These containers were produced before court, and there were often multi-agencies at the scene before this court at Mombasa, all inclusive of the court, counsel for the defense, and also the multi-agencies in Mombasa. Investigations here are in between the containers found in Mombasa and some huge amount of money suspected to be laundered via Financial Report Center, DCI, REF, FRC/4/1A/4/Volume 10, 83, dated the 18th of January 2024. The complainant then was the financial transaction between one Sanjola and a Chinese company. It is for a supply of 84 tons from DRC Congo to China. There is now an extra account of one Mose and Company Advocates based in Nairobi. Mose was to hold the funds until consignment is tested and the funds released. The funds were partially utilized, contrary to the sale agreement. The 3 containers are now found to be with sand soil. The goods arrive in bags instead of drums. The account is being held at Sinian Bank, Naivasha branch. The containers I have read. The order was eventually granted for preservation of the funds by a court of law, awaiting the outcome of this case. Interestingly, Counsel Mose was equally not qualified to handle the money. He is a lawyer, but during the hearing of this matter, he had not gotten his practicing certificate for 7 years. When the containers arrived in China and the same was found to be soil, complainant called the said bank to stop any transactions as she realized that she had been conned. One interesting person in Kenyan soil is PW16. In this court's analysis, this is where the rain started beating us. PW16, Owen Kaseno Kwalia. He is the tax and administrator and works for Kenya Revenue Authority, and that his job description is that he is the head of investigations, Southern Region. He testified that they investigate tax crimes and tax frauds, that on the 16th day of October 2023, they received a call, intelligence of suspicious containers from DRC. He avowed that he spoke to the manager, Customs Investigations, to send officers to trace the containers which were at MCT, that is the Mombasa Container Terminal, and they put a hold, what is called an F-89 customer document, and sealed the container. They never gave them at MTC, but at AGL, formerly Borole, where they were found. They placed an F-89 and sealed the containers, dated the 19th of October 2023, serial number 010401. That after a month, they received an email from Sanjola and ready for verification, and he sent officers to the verification. Samples were taken. Later, accused went to their offices and gave them documents from Uganda, customs. There was raw titanium. He asked them to relax the holding, and PW16 avowed that their role as customs was to facilitate trade, and he allowed the exporter to continue. That his people told him that this had been black soil. He testified that he did not investigate what CCIC Africa, and he did not get the laboratory report, and he released the said documents. Despite all his officers under him and the relevant authorities, both from Kenya Revenue Authority and the other multi-agency confirmation that this was soil, PW16 stopped investigations and did not call his counterparts, even from Uganda, and he believed that there was titanium, and in all the 3 containers, that was it. He communicated relaxation, and he still believed that this was titanium. He testified that he does not know the minerals arrived in China. Now, I think I've read the analysis by Zephaniah Ochieng Ogutu and what was found to be soil in all the 6 samplings that were done. And eventually, this is what the court now says. The accused has testified alone. And this particular witness, who was the geologist, said that he testified that only 1 had titanium contents out of the 9. He testified that he signed the report with the chief manager, one Dr. Jaro Arero, and the manager, Fred Isaboke, which report was adduced in this court as Exhibit 57. Now, once this was adduced to court and there was nothing as titanium which the complainant wanted, that is where everything dropped. Now, having said that, this court finds that the prosecution have proved their case on count number 2 and find that the accused person is guilty on count number 2, and herein convicts him accordingly.